Okay, so we have the recording on. So the session will be recorded, and that's for the benefit of future people who may want to see the questions or discussion in this live session. Also, because it takes a lot of time and effort, and if we keep on repeating the same thing, it will not be a best use of our time. So, uh, right. So one thing, before I start with today's topic, we had covered section A and B in the last discussion. Let me just, section A was about personal information, and section B was about details of any current legal proceedings and any maintenance being already paid. So, all right. And I want to show this summary PDF file. It's only 7 pages. And all these points, except for the last few points about perjury, which are my own, they have been taken out of Rajnesh versus Neha Supreme Court judgment. So basically, these are like copy and paste. So for example, if I say, what is the topic number one or point number one, rationale and history behind maintenance provisions. So these 4 points are taken that directly out of the Rajnesh versus Neha judgment. I have not changed a single word. So the whole idea is that if you read the judgment, it contains a lot of history and discussion of you know previous high court judgments and XYZ things, which may be cumbersome for a layman. If you want to just get to the gist or summary of what Rajnesh versus Neha is all about. So I have put all those points in this PDF file, which I have shared in the broadcast channel also, which is a public channel. Anybody can join it. So and how to join it? You can, if you go to menrightsindia.net contact page, all the links are there of various groups and whatever communities we have. So I will jump to one important point which I think keeps getting repeated in our group also, as regards the procedure about deciding interim maintenance. So what I would suggest is that before you ask question in the group or live Q&A, wherever, please go through these points. And if you have doubts, you can refer to the judgment also. You can ask a question in the group, because see, they have a very clear-cut, procedure as to what the applicant has to do for filing a maintenance application. Then what the respondent husband has to do to file, his affidavit. So there is a maximum period of 4 weeks, right? Uh, on the failure to file affidavit by the husband, it's not mentioned here whether the wife. See, why didn't they mention wife? Because it is expected that she has to file. This is a very, very important point, right? So there cannot be any adjudication of a maintenance application by wife or applicant if the applicant doesn't file a income affidavit. Because if you read this portion on the failure to file affidavit by the husband, it's assumed, because why I'm saying so, it will become clear. The family court may proceed to decide the application of maintenance on basis of affidavit filed by the applicant and the pleadings on record, right? So pleading can include husband's pleading also, in if he has submitted his WS, and of course the wife's pleadings. And it is assumed that wife has filed the affidavit. So this failure to file affidavit is for the husband basically, right? But it is very clear that because this question was there in the group also, that if the wife doesn't file affidavit, should I seek dismissal of her application? Even if you don't seek dismissal, first of all, application cannot be dismissed, just on these kind of technicalities. In my opinion, it's a technicality, because you can always correct this mistake. So the maintenance will be decided based on both income affidavit filed by the wife as well as her petition. in case the husband doesn't file. So if you go through the summary, a lot of the doubts can be clear. Interrogatories are also mentioned. Many people keep asking about CRPC 91. Should I file CRPC 91? Now I understand that it is happening. Courts, some people are able to file CRPC 91 even now. But strictly speaking, now that Rajnesh versus Neha is there, interrogatories is the way forward. Unfortunately, the knowledge and practice of interrogatories in Indian courts is very, seems like it's very rare. So that is some kind of this thing. So in the interim, if you're not allowed to file interrogatory, but the court is accepting your CRPC 91. So if you're getting the job done by, whichever way, you can proceed, so that at least your merit of your case can be come on the record without much, hindrance. So, so I would just wanted to, mention this, that if you have any doubt, quantum of maintenance, how maintenance is determined. Now, this is something which has been there for, 10, 15 years now. Like even now, people have the same doubts. My wife is working, she is qualified, she has left her job. So if you look at this, and many people have a kind of, question, how much percentage will be kind of awarded. So first of all, this itself is the very first line itself says there is no straight jacket formula. So if any husband thinks that, oh, she's earning more than me, she will not get maintenance. Well, who's to say? She may get maintenance if you don't fight properly. Because there is no straight jacket formula. You have to give your pleadings, your WS, your objections, and your income affidavit and your arguments. You have to put it in front of the court. Without doing that, there is always a risk that maintenance may go against you. I mean, the amount of maintenance. Husband doesn't have any source of income, doesn't absolve him of his moral duty. So, end of story. This is a very common question. I wanted to, I know during Corona, I lost my job. Okay, find another job. Because as far the law is concerned, you can't remain jobless for like next 20 years, right? I mean, that's not the plan also, I believe. So look at these things with a very, open mind. Don't put your own thought process that I will get sympathy if I see if there's a genuine reason, somebody has an accident, somebody has a medical condition, then the court is bound to consider. But you have to bring that even that on the record of the court. You cannot simply assume that I will get some consideration based on these things. Okay. Now all the points are there. Maintenance amount must be reasonable and realistic. It should avoid either of the two extremes. So you can argue on this point. This is a very common thing. Many people say that my income is, let's say, 1 lakh. My wife has asked for 2 lakh per month maintenance. So you straight away Rajnesh versus Neha judgment you can quote. It can't be so extravagant. You have to argue that when we were staying together, we were living in a 1 bedroom, 2 bedroom, whatever, X bedrooms of house. We had, car or scooter or whatever. Some people don't even have a vehicle. That is fine. Mention all that. So how can your standard of living suddenly jump from, you know, no car, no scooter, nothing, to a Mercedes, BMW kind of, standards? It's not possible in one day. And these are very easy to prove also, right? How will your wife prove that, her living standard is a BMW and Mercedes and 4 bedroom bungalow or whatever, 10 crore kind of? It's not possible. So there is another judgment quotation here, which is, where they have given almost like all the important points of what all is considered in maintenance decisions. Uh, so, and what I have done is last week's, so there is a playlist. I think there are some 3 videos in on my channel on Rajnesh versus Neha. So, okay. So part one, I think the first video is nothing but the last week's discussion. It's more than 1 hour. And then there are 2 short videos. What if wife doesn't submit her income asset affidavit? So we will discuss. I think this is something we keep on discussing in our group also. This is happening very commonly. And make sure wife is first to submit. That's very, very important because what we are seeing is that courts are asking both the parties to submit on the same day. And this is nothing but like the previous regime where husband will be forced to submit his detail, but wife will keep on making excuses, and she will submit like 6 months bank statement, and she will say, yes, my job is done. Let the maintenance be awarded. So we don't want to allow that. How is it in our benefit, right? And it's not the procedure also as per the Supreme Court. So the first link is the playlist that you can see. Uh, and then, in the last week's video call, we had multiple questions. I think 5 or 6 questions, or maybe more than that actually. So about 10 questions, I have put that along with the timestamp. So if you click on the video, it will straight away jump to the question and answer. So this can save time for future people who want to watch. And also this is a good reference, so we avoid repeating the same questions. So if today we have a same question being repeated, I would instead request the person to go through this and maybe ask in the Telegram group afterwards. Okay, so before we start the from part C on section C onwards, if anybody has question on section A and B, only section A and B, you can ask the question now, and then we can proceed with the today's topic. Okay, so we will have questions later on. Let's go to section C. So this is an important section. Basically, it says details of dependent family members. So now this is something which is applicable for both. It doesn't say whether it's applicant or respondent. So it is very important for husband to not only fill up his own dependent family members' details, but also in case the wife hasn't filed her details properly, uh, you know, check that and put those points in his reply affidavit, right? So first point is relationship with dependents. Now, why this is important is because some relationships are very close relationships, like father, mother, brother, sister. Sometimes people may have, some relative like your aunt, uncle. Sometimes, some relative who's staying. Some people have a divorcee sister or a sister who's separated, and they are staying with, with you. And if she doesn't have any income, or maybe she has income but not enough, so that may also create the financial, dependency. So that is that part. You mentioned the relationships. Now, I think the part B, or the clause B, that is about the age and sex of the dependents. So I guess this is like a very basic kind of information, and that you should state truthfully, because this will help the court to decide on the merits of the both the parties' submissions. And point number two in the dependents is disclose if any independent sources of income of the dependents. Okay, so which includes any interest income. So interest income can come from bank savings account, from fixed deposit, from and like post office. There can be some recurring deposit, or these kind of saving schemes which give you a monthly income or whatever, recurring income basically, or maybe yearly also sometimes, right? So that's the interest income. So assets. Now assets is a very broad word, but I'm assuming it can include like anything. It can include your, especially any income generating asset, like any mutual fund, dividend producing asset. Um, I think it doesn't mention any rental income, but probably that will also come under assets. Like if you have a given house on rent, if you're dependents, then that rental income has to be disclosed here. Pension, that's a simple, in case anybody has a pension. Tax liability on any such income. So that means you have to check not only your own ITR, you have to check their ITR also, in case they are paying taxes and they are filing whatever income tax returns, and any other relevant details. So this is a catch-all phrase basically, like just in case these points don't cover some source of income, uh, you are duty bound to disclose any other source of income, right? Because if you look at the initial point, it simply says independent sources of income, and it has given some points here, but it's a non-exhaustive list. It doesn't say that only these, you can't include anything else. So I think this is a catch-all kind of, it's a very broad clause. You have to carefully check all sources of income. And what will happen is sometime, income may be there, but it may not be enough. Let us say there is a pension or some other source of income, which amounts to 15,000 per month, but the actual expense is 20, 25,000. So you have to say that, there is an income, but still they are dependent on me for that extra money which they need, right? And point three, I think that is like the next step. Basically, it says what I was saying, that whatever approximate expenses which are being incurred on account of dependent. So I guess if there are multiple dependents, you have to mention all of them. And maybe you can, line by line, you can mention if a father is dependent, okay, this much per month. If a mother is dependent, medical expenses also, you can make an estimate of, like, sometimes the expense may happen once or twice a year. So you can like divide it by 12 or whatever, you can mention that yearly this much expense for so and so person. Okay, I think the next thing is coming to medical details only of, but here, okay, let me check. There was one question, I think. Okay, so there is a question which we will take now. It says, in general, wife either fails partially or lies in the Rajnesh versus Neha affidavit. Yeah, that's a very common thing. We are observing it every day almost. In such a scenario, can a husband file fully filled his affidavit, but say in an encoded way, and ready to provide the decoded file? Decode. Okay, so you want to do some software, I mean, cryptography or what? I don't know. Decoded file only after the wife provides complete information. I know encrypted PDF is not allowed even in e-filing, but can this be asked under Section 151? That's a very innovative suggestion, wherein already they use this against the husband to the extent even in striking off his defense. I mean, see, striking of defense has been covered in the Supreme Court judgment also, Rajnesh versus Neha, and they have given very clear guidelines. It can't be done in a routine manner. It is like a, some kind of a, only after he has been given all the chances and he is willfully not submitting, even after giving, uh, his chance and warning him, whatever. So, see, we cannot create the law out of thin air, basically. Uh, because I would say that why don't we ask for striking off wife's petition itself if she is not filing income affidavit? Now, unfortunately, there is no such provision. But if we go at, I think this summary which we were considering, procedure for deciding interim maintenance, if you go to this section, this point which we discussed in the very beginning, which says, uh, on the failure of to file the affidavit by husband that we have discussed already, court may proceed to decide the application for maintenance on basis of the affidavit filed by the applicant and the pleadings on record. So let us say the affidavit filed by the wife is incomplete. Husband has filed the affidavit. Now, I mean, in any case, court will decide based on all the details. So one can argue that her she has come with unclean hands. The person who comes to the court to seek any relief, they have to come with complete information, complete disclosures, and if they don't disclose, adverse inference can be taken against them. For example, if wife submits only 6 month bank statement and not 3 years, so you can straight away ask to take adverse inference. But the problem is that Generally, I mean, husbands in India, most likely, or what we observe, people don't have confidence in the court process. People think that, um, that's what we see on social media. People keep on sharing courts are biased, anti-male, this and that. Yeah, but how do you prove it? Because nobody is giving you any data. Like it may be somebody can do analysis. I think in foreign countries they do this. They have done analysis of bail matters also. If the judge has breakfast in the morning session, you people get bail easily. But if the judge is hungry or something like that, the bail is difficult. I mean, like it's a probability. It's not like zero and one kind of a yes and no kind of situation. So unfortunately, in India, we don't have those data kind of thing. So I would think, this encoded and decoded file, encrypted file, it won't fly because you are creating your own procedure. So okay, you can ask your question.
Am I audible?
Yeah.
Yeah. So what I was trying to say is like, let's take this specific example, right? When you said when 3 years bank statement is required, the party submits only 6 months, and even the husband after insisting on in the court to provide 3 years statement, but the court is not accepting. In the meantime, they are asking the husband to file the affidavit. So we, as an husband, if he wants to give full details, he has to give all the details, right? Like three year statement, everything. So, like what I'm trying to say is like the husband is ready to provide, but the incomplete information only if it is like completely adhered to by the wife, then only he will disclose his thing.
See, I mean, the problem is simply the issue is very simple. If there is a lacuna in the procedure, then we should bring it out in front of the court that there is a lacuna. Now, is there something in Rajnesh person Neha which states as to what will happen if wife is filing incomplete affidavit? Unfortunately, I don't think there is a straightforward explanation, right? So whether it was done deliberately or it's some kind of a omission, it looks difficult that it's an omission because this judgment came about after deliberation and there were several amicus curiae involved who gave feedback to the Supreme Court, on various judgments and all those things. So somehow my sense is that this has been done to kind of remove the friction, basically, kind of like even if she's unable to submit, why create too much friction and this thing? Let it proceed. Now what will happen? What the husband has recourse to? He can either file for a review, recall, whatever in the same court, or he can go to the higher forum. So unfortunately, this is the situation in India that we have very lax standards on perjury. I mean, they are there. CRPC 340 is there. Section 191, 35. Various sections are there. But how often do we see they being used and people being punished? Very rarely. Only for rape cases we see that happening. Otherwise, it's very very rare actually. Right. So my suggestion is you can go through this judgment, and one thing I will suggest is try to read some judgment on perjury. If hiding of information, can it come under perjury? Probably not. But I mean, since you have this question, maybe that's a more fruitful endeavor because if you start asking these things, I will file encrypted, I will file this that. I don't think the courts will be amused. They will pass an see. They have the power to take adverse inference against you. You are not cooperating. So, like I said, in this on the failure to file the affidavit within the prescribed time. So, what you're saying is, I'm giving 30% information, just like the wife has given, and 70% is encrypted in this USB, and password will be given once the wife submits. The court may proceed to file based on your 30% of affidavit, and they may take adverse inference against you also because it's part of the Supreme Court judgment also. If I just go to this, let me check here. Adverse. Okay. I don't think I have put this point in this summary, but definitely it's there in the Supreme Court. This thing. Let's just search for that. Adverse. Okay. Ah. Okay. Page number 42, 43. The onus is not on the husband. Okay. That's Okay, it's only one this thing. So this is not a Supreme Court judgment in Rajnesh versus Neha. This is a one Delhi High Court judgment. You know, if the husband does not disclose the exact amount of his income, and adverse inference may be drawn by the court. So let us say your wife says your income is 2 lakh per month, and your actual income is 1 lakh per month, and you give some, you know, documents to the court which are not complete because you are, doing a tit for tat. Like wife has given 30%, I will give 30% documents. Now there is a chance that court may presume that okay, maybe not 2 lakh, but at least 1.5 lakh, maybe your income. That's the reason you're not disclosing your ITR or bank statement or whatever. And they may proceed to pass the order. So what is your recourse? Then you have to go to the higher forum. And then you will face the same issue that like you will be in the wrong. So the point is, this tit for tat strategy, unfortunately, in matrimonial cases for husbands, it doesn't work. This is again a common kind of thought process in many minds of many husbands that if the wife is able to do something, if I do the same thing, will I get the same result? Unfortunately, no. You will be punished because see that is the societal standard basically. I think the feminists are the one who say that don't have double standards, but double standards are already there against men and husbands. Like you won't be judged by the same yardstick how they will judge a wife. You are able-bodied, you are supposed to work. Even by physical labor. Wife is able-bodied, no problem. Even Supreme Court judgment, you will not find a single mention of anywhere where if wife is able-bodied, she should do some work or at least do some honorary work. If you can't, we are not even saying you do some, earn some money. Go to some community center, Anganwadi, whatever, social center. Do some work for at least 20 hours a week. There is nothing like that. So that is a double standard of society. Supreme Court is only following, what the society believes in. So that is the, reality. So I would suggest if you want to spend your time and energy, focus on something like perjury, maybe if you can find, maybe unclean hands. What happens is, when a person doesn't give complete information. I think my understanding is that it's a normal process of law. If you come to seek relief, you have to give full, document and details. Otherwise, you're not eligible, or at least an adverse inference should be taken against you. But so far, I think we don't have any such judgment. So whoever is suffering, they have to try it out, basically. Okay. Uh, okay. There is another question on dependents. If brother is facing from psychological, psychiatric issues and not doing job, can it be mentioned as dependent and with health issues medical report? This expenses can court consider it mentioned in affidavit in C and D in Rajnesh versus Neha affidavit. Yes, of course, they can consider. Uh, See, the point is that if somebody is having psychological issues and unable to do job, then the what's most important is that medical report. Now, if he has not been doing job for like even before your marriage, then it's not like a new thing. So why cannot use? I mean, they may want to use this logic that uh, you're saying this only to say save some maintenance. So then you have to say that this medical issue has been there for last like so many years, not like after you file maintenance case. So court will consider all these things on merit, and I think the medical issue should be of such a nature. It should be serious enough that person is unable to do a job. But then again, it's if it's the husband's brother, um, and it's already that's happening, and the certificate is not a fake certificate. It's a condition which is there from even prior. I don't think the court would want to go too much into the details as to because if husband says that I am suffering, then it's a different point. Then they may scrutinize your condition with a fine kind of lens, but it's your relative, so it's a dependent. So you should definitely mention this because this is something which is unfortunate, but it's the reality. So you have to disclose. If you don't disclose, then later on you will suffer. See, the point of law is that you get a chance to disclose at the right time. You miss the bus, then later on you say, "Oh, after maintenance order, oh, Your Honor, I forgot to disclose." Then you are the one who will be troubled, basically. So don't miss the bus, basically. When you get the right time, make sure you mention your details at the right time. Okay, let me go back to section D, medical details, if any, of the deponent. Okay, so I think, yeah, point number two was if any dependent. Okay, I think point number one first, whether either party, husband, wife, or child or children is suffering from any physical, mental disability or any other serious ailment. So this is for serious things, not like a common cough, cold, these kind of things. If yes, produce medical records. So I know of a case where the son had somebody's son had some serious condition which requires, like, I mean, a lot of money expenditure every month on hospitalization and, like, some treatment. Um, so that you should disclose those kind of things in this point here, and produce medical records. So this is where the producing documentation, having up to date records, that becomes very, very important, along with your pleadings, along with the submissions. Now, point number two is if any dependent family member has serious disability requiring continuous medical expenditure. So this is again in the nature of some kind of a chronic ailment, chronic disease, which requires some thousands of rupees of expenditure every month or something like that. Then you produce, if disability certificate, you produce that. Okay. So I think this is only for serious disability. So you mentioned so I believe this certificate you have to produce from some kind of a recognized medical institution, because so that's what you should do. Point number three is if either husband, wife, or children or any family member is suffering from life-threatening diseases, which would entail expensive and regular family expenditure. So again, the idea is not your routine once in a while expenditure, but something which is like a regular basis. So some people have, I think, dialysis or those kind of things, which is like a regular thing. They have to keep on taking those treatments. So that you should mention here. And yeah. So along with summary of the previous details of hospitalization, medical expenses incurred. So I guess this is to give the court an opportunity, or kind of the necessary information to be able to arrive at a fair conclusion as to your condition is taking how much expense on currently, and also how much is it was prior, like maybe 1, 2, 3, 4, 5 years back. So if you have like a very old records and there is a expenditure, definitely submit it, because it will give that you know confidence to the court that you are not coming with something which is very new. Because generally in courts, see, courts, it's a legal, unfortunately, it's an adversarial litigation procedure. So opposite side will try to poke, in case you don't give any, document of, like, let's say last 2 years, even though you have it, the opposite party may say that, this is a very new condition. You are making it look like as if it's a 5-year-old condition. So why do you want to hide your documentation? If you have document, produce it. That will only benefit you. So I think these two sections on dependent family members we have covered. And uh, so for the husband, I think this is pretty straightforward, because this is on in your knowledge. This is something, uh, and this is also important. Okay, I think this is one important point. Many times what we have observed is that when the wife files her maintenance and there is a child, she will put, like, 20,000 monthly expense on medical expenses for the child, and it's just a figure, in the application, without any breakup, without any explanation, what exactly the and child is healthy. I mean, like, he doesn't have anything, you know, none of these points. There is no disability, there is no serious ailment. See, routine things we are not saying. Some common cough, cold, viral fever once in a while. That's a different point. But there is nothing serious. Again, There is no life-threatening disease. In most cases, that's what we observe. So how can your medical expenditure of child be 20,000 per month? So when you have to argue in the court, when you have filled this affidavit, as per your knowledge, see, sometimes your custody won't be with the father, not sometimes, like it's a very common thing actually. So you may not have the latest information with you, but to the best of your knowledge, last time you saw the child, maybe 6 months back, 1 year back, or whatever it is, you say that, I have the complete, when the child was with me, uh, child was healthy and child didn't have any serious ailment. And if you have any medical records, of small ailments, you can even keep that. Not to prove that child was sick on those days, but to say that I have maintained the records, so I know my child's health. In case the wife has any records of her own, let her bring to the court. So that will be your plus point, because that's where the record keeping is very, very useful. Whatever, if you have some old records of the child, doctor visit or vaccination, whatever it might be, you can mention that, I'm showing this. Where is the mention of any serious ailment? When you have shown the doctor to a pediatrician, the doctor has not mentioned any serious ailment. As a doctor, it is his job, right? He won't simply say that, okay, I will treat the cough and cold, but I won't worry about the serious ailment. Go to somebody else. I mean, it's possible in case it's a specialist kind of a situation, but so once you produce your documentation also, then the onus shifts on the other party, that let them produce some document which says that no, the child is having some serious problem. And that's the reason I'm spending 20,000 per month on the child. So I think this point, we shouldn't ignore it. Like, it looks very simple that you may say, okay, yes, no, nothing major, okay, you may just kind of, but this is how you should argue in the court, right? So, okay, I think there is no pending questions. So what we will do is we will go to the next section, which is details of children of the parties. Okay, so number of children from current marriage or previous marriage also. So it is like exhaustive, because children will be financial responsibility will lie on the parents. Name and age, that's very, very important, and it's a very obvious thing also. Without that, it will be incomplete. Um, this is interesting. I don't know whether it will create a problem, but sometimes we have seen that the wife will change the name of child in the school records without informing the father. So I don't know what will happen if the wife gives one name and the husband gives another name of the same child. And but well, be prepared and point it out in case it happens. And you go by this, your record, like whatever you have as per the name which you gave. Okay, point number three is details of the parent who has the custody of the children. Details. Okay, it's not very clear what is meant by details of the parent. I mean, if it says the name of the parent, that's one thing. But so fine, you mention your wife's name or whatever here, and we will come back to it in case we get more clarity in subsequent sections. Expenditure for maintenance of dependent children. Okay, so this is where we come to the gist of child expenses. Towards food, clothing, and medical expenses. Now, here, what some people may say, especially fathers who don't have custody, that I do not have knowledge because child is not with me. So mention some estimate. You can even say that, uh, give some estimate and mention in bracket parenthesis that this is my estimate. And also because when the child was living with you may have some estimate from that time, which is a realistic estimate. So you can mention that, at that time the food clothing took so much expenditure. Right now the child is going to school or whatever. So add that much for education. And so one should always give some estimate because otherwise the same thing will happen. The wife will say medical 20,000, uh, nanny 10,000 rupees, maid, there are one maid and one nanny. So like all kind of, expenses piled on for in the name of child maintenance. Uh, Point number C, towards expenses if any of any extracurricular, vocational, professional, educational, specialized training, special skills program of dependent children. So I think this includes anything which is beyond the studies and schools of the child. It includes the tuition fee for any tutor, which is very common in India. I have seen even like children in class 5 going to tuitions. So it's like so people don't have faith in their school basically. That's what I feel. Any other vocational? I don't know. Like okay, so generally vocational is for like you want to train for some skills. Like uh, so a small child, what vocational this thing? Okay, I think vocational can mean. Let me just Google search. I think the names, skills, knowledge you need to do a particular job, particular job. So that is the general meaning actually. Career, yeah, I think that's the general meaning. So somehow I'm not sure why they mentioned this here, but probably it mentions extracurricular. I don't think it means like you're training your child to be a plumber, electrician, carpenter, those kind of skills. Professional educational course, specialized training. Okay, yeah, it will include all your music, drawing, martial arts, judo, karate, whatever, XYZ. So that is where you husband should be careful because this is again one point where wife will try to inflate the maintenance amount for child. So watch it closely and argue on this point. Especially when the child was with you, child was not going any of these things, like or maybe one or two things, and now suddenly he's like at that time child was having 2,000 rupees per month on point number C, and now suddenly wife has custody and she's saying I need 20,000 per month for all these extracurricular things. So produce your I mean state your points that this was the expense when the child was with me on XYZ, and I have the bills also. Mention all those things. And details of any loan, mortgage, charge incurred on account of educational expense. I think this will be more valid for maybe children who are in higher education. Generally, at school level, people don't take loans for children's expenses. But well, if it is the situation, parents have taken loan, or then that's what needs to be mentioned here. Any EMI which you're paying for an educational loan of child. Point number 5 is very, very important. Whether any voluntary contribution by either of the parties is being made towards these educational expenses. Also provide an estimate of any additional contribution. Right. So this is where I think my general suggestion becomes important, which I tell fathers, is first of all you make some voluntary contribution on these things every month, even before any maintenance order. This is something you can start right away, and it need not be like very high amount. This is only for food, clothing, medical, basic things. For education, there is a problem. Sometimes the father is not even aware, or basically it's deliberately done that he is kept in the dark as to the which school the child is going to, right? So I would say it's your duty to ask the wife that what school he's going to, he or she, and you can even offer that I'll pay 100%, 50%, 60%, whatever is as per your relative income levels. Because if she doesn't have income, then 100% expense of this education will come on your shoulder anyway. If not today, in the future, along with areas. So, and the bigger problem is that there is a psychological, bias or rather I mean, what's the opposite of sympathy? So instead of getting any sympathy, you will have the opposite effect that, you were not responsible. You neglected to even ask your wife about the child's school and expenses. And it's already been 2 years. So many people say on social media, I have not seen my child for 2 years. Okay, fine. Have you filed child custody case? No, no, I have not filed. Some people say, well, there's no use also. I will never get any custody. She won't allow me. Okay, fine. Expenses for the child. Why should I pay expenses? You know, because my lawyer says pay it only once the order is comes. The problem is your maintenance order will come like, but at least 2.5 times in that scenario. This is the practical observation we are seeing. This is not something we are saying out of thin air. So if you don't make voluntary contribution, generally the overall maintenance will increase. And sometimes they say for the child specifically, sometimes it's the overall. And whatever you saved earlier, now you have to pay like, not only pay that much, you have to pay, end up paying a lot more in future. So that's a very unwise thing, I would say. Like, just to live in your own kind of corner that, okay, I will see what happens. Yeah, I mean, see, that's what I say in my Telegram group. I said, no, there is many people have this hero mentality. Like, I'm the hero. Many people before me have failed. I will succeed there. That won't happen. It's not easy, basically. Right. Okay. Point number 6 under children. Whether any financial support is being provided by a third party for the education of children. So basically, third party would be not husband, not wife, basically neither of the parents. It could be a grandparent also. It could be some uncle, aunt. I mean, depends actually. So if it's in the knowledge, if it's happening, then this thing. Um, so I mean, I've not seen such a case, but it is possible in those cases where the many a time the mother or the wife will keep the child with her parents and she will be doing a job somewhere else. Then this is very much possible that the grandparents are taking care of some of the financial expenses of the child. So in that scenario, it may be applicable for the wife, basically, not so much for the husband because he doesn't have custody, right? Okay, if any questions on this topic, details of children of the parties, whether you should make any voluntary contribution. Okay, so now we come to the section F, which is probably the one of the most important for husband. Details of income of the deponent. So name of employer. Okay. What about business people? Huh? They have not mentioned anything about. Okay, fine. So the first point is applicable for people who have like employer salaried income. Designation again for employees. Then monthly income. Now this is where the question will come. Like, is it gross income, variable pay, bonus pay, this that? Somebody was asking my bonus pay. I have variable pay, which depends on company performance, business performance, XYZ, group performance, individual performance, of course, that may also be a component. So, I think his question was that my salary slip includes that variable pay, even though I may not get it. So that's very unfortunate because, like, the company is doing an advertisement that we are paying you 100, even if when actually you're receiving only 60 or 40. So I think in those scenarios, you should definitely disclose the reality that what is being disclosed here in my salary slip, it is not my actual net hand kind of income, what I get after deduction of PF. So I think this can include your HRA, your perquisites. I think that's part of section 6. So you have to make some kind of educated, not educated, but a common sense guess as to what is meant by this. If you have those, very fancy kind of items like variable pay, bonus, commissions, those kind of things. If you have a very straightforward kind of fixed income per month, then it won't be much of a problem. You can straight away mention your monthly income as per your records given by the employer. Now, for people in government service, you have to submit latest salary certificates or payslips or proof of deposit in bank account if being remitted directly by the employer. So for government people, they have like special provision like this salary certificate or payslip or even bank account statement. Now for private sector, again, I mean, there's a separate provision. Furnish a certificate by the employer stating the designation also and gross monthly income of that person and Form 16. So I guess Form 16 itself will have a lot of information. So in a way, actually, Form 16 will be useful for those people whose gross monthly income, any extra thing which company is saying we are paying you this much, but actually we are not paying. Form 16 will take care of that because that is based on the actual payments, what they give to the employee. So lot of disclosure here. There is not much, I mean, there's no way to hide basically. That's the whole purpose of this affidavit. And I guess, this is what happens when individual people, they try to get smart that, we will outwit the legal system. I will somehow delay the case, this, that. Now that's fine, you did it for 5, 10 years. Some people got some benefit also. But now, what's the situation now? Now everybody has to give an affidavit. So ultimately, the only solution is to strengthen the perjury and these kind of laws, and punish non-disclosure, like not just perjury. So without that, the problem will not go away. I mean, it's an old problem. Now there's a new problem. That requirement is there for both people to submit, but the wife doesn't submit full detail, and husband is pressurized to submit full details because he's the earning person, as per Indian kind of societal mindset. Husbands work and earn, and so women like. I mean, any number of judgments keep coming all the time that she's qualified. Uh, that doesn't mean she has to work, or I mean, so that's the kind of current paradigm basically. But the same Supreme Court, if a woman goes and says, I'm getting only 80 rupees, my colleague is getting 100 rupees, they will definitely say, no, no, you are equally qualified, you are equal, so you need the 100 rupees as much, same as the this thing. So that's where the equality comes basically. When you benefits, you have equality. When it's responsibility, then you don't need to work. Unfortunately, that's the reality. So coming to point 6, any perquisites, benefits, HRA, travel allowance, dearness allowance, or any other service benefit provided by the employer. Okay. So I guess this is pretty much clear. You mentioned any benefit which you are getting and using it, but let's say there's a benefit which you have, but you have not used it. So you need not mention, or basically you can say that, I mean, it's there on the record, but maybe the document shows that, this is my, because, what will happen is when the company gives you the certificate, private sector people, they will mention, whole laundry list of benefits which they are giving you. Um, Monthly allowance of books, some family kind of, allowance, some this, that. But you may not be able to use that all of it basically. So make sure you mention that, like in case you're not able to use all of it, because otherwise the court will presume that you have that much of perquisites and benefits, right? Whether assessed to income tax. If yes, submit the ITR for the periods given below. Okay, now it's very, very clear here. That's where the confusion was. So that's not the bank statement, I think. This is for the ITR. 1 year ITR prior to marriage. So that will take care of your, income at that time. 1 year prior to separation and at the time of maintenance application filed by the wife. So these 3 things you have to take care of. Let me see. Okay. So any questions on this ITR? I guess it's pretty straightforward. The only thing somebody may say is ITR is from financial year, basically from 1st April to 31st March of next year. So if the wife got separated or left the house on February of 2023, now ITR means ITR till March 2023 or till March 2022. That is something which I think it's not like very clear, but I would take an educated guess that you try to overlap the period, like what's the maximum overlap? So somebody leaves in February of this year. So already they have spent like 11 months almost, you know, of this financial year. So this financial year, uh, you know, ITR is important, right? But this is some kind of a, question mark kind of thing where I guess if people have some advantage, they will try to use it. But then the opposite party can object. So, that's how litigation goes. So I'm just informing, what possibility may arise. Okay, we have one question. Yeah, please ask your question, Arunji.
Hello. Yeah, I have a question regarding the ITR. Normally, the judge asks in a way that provide the ITR for the preceding last 3 years. So even in this judgment, it is written that it has to be 1 year prior to marriage, prior to separation, and the date of application. But normally, judges ask for the preceding 3 years. So what shall we consider? Shall I consider that the
No, I
day
mean,
are
see,
you filing the
I mean,
affidavit
see,
and then last
judges,
3 years, or
I mean, see, it is part of the judgment itself. Maybe they are saying it is very clear here. So you need to mention this is something your lawyer can easily inform the court, or if you're a party in person, even you can inform the court that this is the ITR as per this thing. Because I will tell you what will happen. If you submit last 3 years ITR, what you're saying the judge has told me, later on your opponent advocate will say, Your Honor, they have not fulfilled the condition as per the affidavit. Now you have to fill up 1 year prior to separation, so you will end up filing 5 ITRs. So is it in your interest to file five ITRs? See, the more information you provide to the court, uh, generally the income level in India will keep increasing for salaried people based on inflation and all these things. The more ITRs you provide, the less benefit for you.
yes?
So I would say, see, it's very straightforward. If court is asking you to do something which is not as per the thing, you file a memo in the court that you can produce the 3 ITRs and you can file a memo that, Your Honor, I am filing these 3 ITRs, and you file a memo that this is as per the copy and paste this para out of the affidavit format and the judgment, that this is as per the format of. And so once this is on record, later on, if the judge says in the judgment that the respondent husband has not provided the last 3 years ITR and hence, I will take an adverse inference, then you go with the memo, certified copy and order copy and go to the higher forum and appeal that the judge has not followed the procedure laid down by the judgment, Rajnesh versus Neha judgment. So that is your recourse. But do not end up following blindly what somebody says, because this will keep happening. I'm saying, whoever, this is something not new thing actually. People who try to appreciate the law, understand the law, they will be able to, uh, take advantage of that knowledge. But if you don't, then your lawyer says do this, you will do that. Later on, it went against you. Oh, it's too late. Or, you have to spend extra money for appeal and this and that. So
Yes,
this is
even
like,
for the yeah, even for the salary slip also, it says just provide the salary certificate or salary slip. It doesn't say that provide the last 3 months or last 6 months. But normally judges ask, okay, provide the last 3 months salary slips. So for that also we can do the same, or we should provide.
you provide the certificate as given by the employer.
Hmm.
See, I mean, this doesn't say any 3 months or 6 months, because if you go by that logic, why not 12 months? Why not 24 months?
Right,
Why not your
right.
previous employer also?
Yes,
You may have
yes,
worked in, for last 5 years, produce salary slip of the last five, all, this thing. See, try to understand, if the courts are, trying to create some procedure which is not as part of the Supreme Court laid guidelines, it is your duty to, and your lawyer's duty also, to inform the court. Not simply, stand there like a dummy and nod your head. Because this is the problem in India. We have too much deference to authority. The reason being very simple. Why people, defer to authority is because they feel that authority will strike down on us. Like, even though what we are saying is the truth, Satyamev Jayate is very nice slogan and all that, Upanishad is all there, but in reality, it may not work. So people say, let's be practical, what's the point of uh, kind of, uh, going against the authority figure because they are the ones who are sitting in judgment in front of. Same with police, same with, any kind of in educational institution. Your
Yes.
professor may say something wrong, but you will say, no, no, I will write the same thing in the paper because otherwise he won't give me marks, right? So this is the authority kind of, fear of authority in India, which is very common thing actually. It's pervasive. It's everywhere. But if you go with that, then and if you suffer, then I mean, who's to be blamed? Because see, you can take a risk assessment that okay, there is a risk in this, there is a risk in that. But if you take an approach, then don't blame somebody else. Like you took the risk of one way or the other, right? So you will
Yes.
say, I will not offend the judge. Let me take the risk and I will give my 3 years salary slip. But it went against you. Now what will you do? You yourself have
Yes.
given the data. So, and
Yeah.
first of all, one thing I will tell you. Whenever these things are told, they are told verbally in the court. Has the judge given you any order sheet? Has the judge written an order sheet? The respondent is supposed to, is, directed to provide 3 months salary slip or 3 years ITR. Is it there in the order sheet? It's not there. It's verbal. So
Yeah.
you make the
For
decision based on that. It goes against you. You have no recourse basically.
right.
You can't even
For
blame.
my case, they have he has given in the written that provide last 3 years ITR, like presiding 3 years ITR.
No,
So
what is the background of that? Why did it happen? There must be
that
some
might
background, no? Like why is the judge doing all the extra thing? It's already part of affidavit. Otherwise, tomorrow each judge will keep on writing. I direct the, provide you HRA and all. I direct you to provide. It's already there in the affidavit. So either you have
mm,
not done it on time, maybe that may be the reason,
yes. And
right?
so the last question I have for the bank
No, no.
statements.
What was the reason the judge has written it?
Uh, I think he has written just I mean submit along with WS submit the last 3 years ITR and the bank statements.
Huh. So you submit a memo, which we have shared in the Telegram group also,
Mm.
which discloses all the procedure basically that respondent is supposed to file within 4 weeks of wife filing. So you follow that procedure basically. If the wife has filed, then you go ahead. If it's incomplete, then it's a tricky situation because nobody knows what is supposed to happen, unfortunately. Like you may say that I will not file until she files completely, but your advocate will say, no, 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 don't do that. So that's the reality. I mean, like somebody wants to challenge it all the way to High Court, Supreme Court, you can. That how to force a wife to submit her complete documents before the husband submits. But I don't think that challenge has happened so far. So I would say that this is the procedure being created by the judge. What you can do is you can ignore the direction also because see, a direction which is not as per the law, it is not illegal to ignore it. You can submit your complete this thing and mention in your memo that I have given as per the arrangement with Neha. If he's still unhappy, I don't think he'll be unhappy. There's no reason to be.
Yeah. Same for the bank statements also. The last 3 years should be calculated from the date of application or on the date when the affidavit is filed.
See, bank statement, furnish copies of bank statement of all 3 years. This is okay. So we are coming to that. Let's come to that point and then we will have the question.
Yes, sure. Thank you.
Okay. So let me just go to. Okay. So we had covered till point 7 ITR, and we have taken the question on ITR also in case the judge is asking to produce ITR for last 3 years instead of this as per this procedure. Okay, so income from other sources such as rent, interest, shares, dividends, capital gains, fixed deposit, post office, mutual fund, stock, debenture, agriculture business, everything. If any, along with TDS. So I think these days, if you check your Form 26 AS, and there is something called AIS also, annual information, AIS basically. I don't, what is the S for? I don't remember. Which contains all your details of various earnings from various kind of uh, the income tax department is collecting all this data from various, mutual funds, banks, various sources. So if you check that, you can get that very easily from there, from their income tax website. Download it, and from that you can fill it up. And the one advantage is if you fill up from that, then nobody can question that, you have tried to hide any information. I mean, that's a suggestion basically. If you already have your own calculations of all these things based on your bank statement and whatever you have, then you can definitely fill up on your own also. So I think this is a pretty exhaustive list, and capital gains. So that will take care of any stock options, those things also, right? Okay, point number 9. This is, I think, a major contention point. Furnish copies of bank statement of all accounts of for the last 3 years. So I think logically it means last 3 years as on the date of submission by husband. Uh, Now something was there in the judgment. Let's have a look at that. Let us. Okay, these are, I think, the same affidavit format only. I remember seeing somewhere, I think maybe it's for the ITR, not the bank statement. Last 3 years bank statement. Or this is about from the judgment. Hmm. Okay, I think bank is different from ITR. Bank statement is only for 3 years as of date of submission. Okay, there is one more question. Same question. Okay, my understanding is that everything needs to be taken from the date of signing of the affidavit, unless specified otherwise. So, salary of month before signing the affidavit. Yeah, that's logical. There's no problem in that. Point 5. Okay, let's open point 3 is monthly income. Yeah. See, actually, I would suggest, let us say your monthly income had a jump in the last 1 month by 30%. How is it beneficial for you to submit last month's, salary slip? Maybe in that scenario, it's better for you to take the last 12 months, total it up, divide by 12. That will be lower than last month's sudden 30% jump. So this is I mean, I think this is a common sense kind of thing. Like, and this is where I think, in case the husband shows less income than what the wife thinks, then they will say, "Oh, please produce your uh, salary slips for last, 12 months." And these things used to happen in the previous regime. This is a very common thing. Endless bickering, on both the sides, and various kind of stratagems and techniques how to avoid and delay giving information. So, um, but if you want to submit your last month salary slip, it's okay. I mean, nobody can say it's wrong. That's also fine. Okay, last available form 16. Yeah, I mean that's okay. ITR of specified period, that's already clear. Bank statement of last 3 years. Yeah, I think so. We agree on all these points that we are going strictly by this thing. ITR as per this, and bank statement as of 3 years. Okay. Okay. There's one more question. If last year's salary slips does not reflect LTA, but recently they started to show LTA in the slip, which one should one submit, with or without LTA? Now, this is exactly what I was saying earlier. That okay. So I think logically we already covered that it should be as of time of filing your affidavit. So if you have this month's salary slip, but you submit last year's, then obviously the other party may take objection. Not only that, the court may draw an adverse inference. So be very, very careful with that. Now, coming to the LTA part, what is LTA, leave travel allowance? So my understanding is that this is something which is um, it's like a perquisite basically. Like if you travel, if you have that money, only then you will be able to use it. Otherwise, it goes away. Also, one may have this question as to why this should LTA amount should be used to decide on maintenance, right? Because this is not an in-hand salary that you can use it to buy some groceries or clothing or whatever else. Is my understanding correct as per the current definition of LTA, or is it LTA something like a cash component? They will give it to you, whether you travel anywhere or not. That's up to you. So it's a cash kind of benefit. If that is the scenario, then LTA, I think, it's almost like a part of your salary because there is no condition that you have to spend it on travel. You can pocket it and spend it on anything you want. So logically, whatever you have the latest salary slip with or without LTA, I think you can show it. In case the opposite side has any objection, then you counter it basically. That should be the right approach. Okay, the next question is mutual fund doesn't generate any income. Yeah, I mean, there are different type of mutual funds. There are some dividend mutual funds which give dividends. Maybe you are invested in a equity or capital gains. Basically, like without dividend mutual fund, which is also fine. Uh, Whether it should be skipped in point eight. Point eight was income from other sources. Yes, you can skip because this is not about assets. This is about income. You may have a mutual fund of worth 10 crore, but there is no income. So, as per my understanding, it's only a income which we have to disclose here. That is interesting because my understanding was that this was the income assets affidavit. Okay, there is assets in the next section. So I think this we will cover in the next Sunday because, like I said last time, these will take several hours. So we will take it slowly, step by step. So yeah, you can skip the mutual fund if it doesn't rate, but in the next section, I think your mutual fund investment may come into the picture, right? Because that's an asset, even though it doesn't give any income as of now, right? Um, okay, any more questions, or we can close? Today we have covered, I think, C, D, E, F, four sections we have covered, and now we have left only section G and H, I, J, K, analyze and all that. So five more sections are left. So probably next Sunday we can cover all these. Okay, thank you all for your time and joining the session. I will put the recording sometime today evening. And if somebody can help me in, questions, like if somebody can send me the timestamp as to, where each question starts, and then share me the link, because then it will be very easy for me to, put that in the sheet. I can also do it, but if, because have already gone through the live video, if anybody goes through the live video and you can just, on YouTube, you can, press share and then copy that link location on this time. It will give you the timestamp location. So if you can share that with me, yeah, so thanks, Sandeep. So I will put that in this videos list, which I have created yesterday. So that will be very, very useful for, everybody, because it's a very good reference resource for future. All right. Thank you all. We will close the session now. So see you next Sunday.